Everyone thinks an irrevocable trust is locked forever. That's what families believe. That's what advisors repeat. And in Florida, that can be dangerously wrong, because I've seen families lose control of millions, not because of bad trust, but because they believed the wrong rule. All right, let's dive in. I'm Santiago Cueto, board-certified international business law expert and best-selling author based right here in Miami, Florida. And today, I'm going to break down the #1 myth about irrevocable trust. This is something that a lot of families in Florida misunderstand and just flat out get wrong. All right, here's the myth. Once you sign an irrevocable trust, it's permanent. End of story, no changes, no flexibility, no second chances. That sounds safe and it sounds clean, but it's also incomplete because Florida law doesn't treat trusts like stone tablets. It treats them like legal instruments with purpose. And when that purpose breaks, Florida gives you tools. But here's the problem. Most people don't know those tools even exist. So here's exactly what happens. A trust gets drafted 10, 15, 20 years ago, different laws, different family dynamics, different intentions. Then life happens. Divorce, a beneficiary who shouldn't get access to money, a trustee who shouldn't be in control anymore, and everyone just accepts it because they think it's irrevocable. Nothing we can do. And that assumption, that's where families get trapped. Florida actually allows something called a Nonjudicial Settlement Agreement, which means the interested parties can agree to resolve certain trust issues without going to court. That sounds powerful because it is. And here's the catch nobody tells you. You cannot use this to do whatever you want. Florida law says the result must be something a court could approve. So no, you can't just rewrite the trust because it's inconvenient. This is not a loophole. It's a controlled tool. Now here's where it gets more interesting. Florida law allows non-judicial modification of an irrevocable trust after the settlor dies, but the requirements are strict. You need total agreement from the trustee and every qualified beneficiary. Miss one person and it fails. And not every trust even qualifies under the statute. So again, this is not easy, but it is possible. Hey, quick pause here. If you're finding this information valuable, go ahead and hit that like button. It helps this video reach more business leaders who could use this content right now. And if you're not subscribed yet, subscribe now so you don't miss the next update on Florida business law. Now let's talk about the heavy hitter, court modification. Florida courts can actually change an irrevocable trust. Yes, change it if the purpose no longer makes sense or circumstances changed in a way the creator never expected, or the trust has become impractical or wasteful, or the original goal has already been fulfilled. This is where the law becomes logical because Florida focuses on intent and purpose, not blind rigidity. Now let's talk about the one everyone throws around, decanting. This is where a trustee can move assets into a new trust with updated terms, and it sounds like magic, but it's not. Because Florida law puts serious limits on this. Everything depends on the trustee's power, especially their ability to invade the principal. If that power is limited, your options shrink. If it's broad, you may have some flexibility. But even then, Florida protects beneficiary rights, and it protects tax consequences. So if someone tells you, don't worry, we'll just decant it, that's a red flag. So here's the real takeaway. The question is not, can this trust be changed? The real question is, which Florida statutes, if any, applies to this specific trust? Because there are multiple paths, and each one has rules. Miss the rule, you lose the option. So yes, you can change an irrevocable trust. Families are wrong about irrevocable trusts, but the real mistake isn't thinking they're flexible or thinking they're permanent. The real mistake is not understanding the system at all. Because in Florida, irrevocable does not mean impossible, but it definitely does not mean easy. If you own a business or your family has significant assets tied up in a trust, you don't want assumptions, you want precision. Because one wrong move here doesn't just cost money, it can lock your family into the wrong structure for decades. And that's a mistake you don't fix easily. Now, if this video helped you see how Florida law actually treats irrevocable trusts, and more importantly, how to avoid getting trapped by the wrong assumptions, make sure you hit like and subscribe. I break down real legal risks Florida business owners and families face in plain English so you can protect what you've built before it becomes a problem. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.